5, 4, 3, 2, 1, start. In sum and substance, keeping in view the sequence of events, two things are clear that the argument raised by Mr. Ravinder Singh, Senior Counsel for the petitioners in CWP number 175 of 2022 is substantiated by the record as such that the whole process was sought to be derailed on account of a representation filed by a third party element being a district court lawyer who was pushing a certain set of candidates in his objection raised to the state and who had no locus standi in the matter, but the state proceeded to act on the same and went on to consult the Union of India without getting back to the High Court. Full stop. The same is apparently in contradiction to the procedure which is prescribed under Article 233 of the Constitution of India. Full stop. The element of a third private party having been introduced by the state has done extreme violence to the selection process and derailed the same, which we will go on to discuss further, and the justice delivery system in the state of Haryana has been set back and badly impacted and continues to suffer on account of the fact that the state government showed its proactivity in a case where it was not required, and rather than permitting the officers who had been duly recommended, it has apparently sought to push the case of the non-meritorious candidates in spite of the fact that the rule provides otherwise. Full stop. The settled case law starting from 1960s would go on to show that law has already been crystallized on the said issue, and the power of this court as such by specific observations that no third party as such can come to the picture when the consultation takes place between the governor and this court. Full stop. In Supreme Court case Supra, the dispute as such was regarding the requirement of district judges and whether the rules framed by the governor empowering him to recruit district judges from the judicial officers were unconstitutional. Full stop. Stanza. The constitutional bench had accordingly held that the High Court was reduced to a position of transmitting authority of the lists of suitable candidates for appointment prepared by the selection committee. Full stop. Resultantly, while allowing the appeal, it was held that the mandate under Article 233 of the Constitution could not be disobeyed by not consulting the High Court or by consulting the High Court and also other persons. Full stop. It was further held that the constitutional mandate was clear, that the High Court is expected to know better in regard to the suitability of a person belonging either to the judicial service or to the bar to be appointed as district judge. Full stop. Relevant part of the said judgment reads as we are assuming for the purpose of these appeals that the governor under Article 233 shall act on the advice of the ministers. Full stop. Stanza. So the expression governor used in the judgment means governor acting on the advice of the ministers. Full stop. The constitutional mandate is clear. Full stop. The exercise of the power of appointment by the governor is conditioned by his consultation with the High Court, that is to say, he can only appoint a person to the post of district judge in consultation with the High Court. Full stop. The object of consultation is apparent. Full stop. The High Court is expected to know better than the governor in regard to the suitability or otherwise of a person belonging either to the judicial service or to the bar to be appointed as a district judge full stop. Therefore, a duty is enjoined on the governor to make the appointment in consultation with a body which is the appropriate authority to give advice to him full stop. This mandate can be disobeyed by the governor in two ways: by not consulting the High Court at all and by consulting the High Court and also other persons full stop. Stanza. In one case, he directly infringes the mandate of the Constitution, and in the other, he directly does so, for his mind may be influenced by other persons not entitled to advise him full stop. That this constitutional mandate has both a negative and positive significance is made clear by the other provisions of the Constitution full stop. These provisions indicate that the duty to consult is so integrated with the exercise of the power that the power can be exercised only in consultation with the person or persons designated therein full stop. We would therefore hold that if the rules empower the governor to appoint a person as district judge in consultation with a person or authority other than the High Court, the said appointment will not be in accordance with the provisions of Article 233 of the Constitution full stop. In Chandradeep Singh HCS and other supra, a four judges bench held that if the recommendation of the High Court was not to be binding on the state, the consequences would be unfortunate. While dismissing the appeal filed by the state against the judgment of the full bench of this court, which had quashed the order retiring the officer from service against the recommendations of this court full stop. Relevant portion of the said judgment reads as the control vested in the High Court is that if the High Court is of opinion that a particular judicial officer is not fit to be retained in service, the High Court will communicate that to the governor, because the governor is the authority to dismiss, remove, reduce in rank or terminate the appointment full stop. Stanza. In such cases, it is the contemplation in the Constitution that the governor as the head of the state will act in harmony with the recommendation of the High Court full stop. If the recommendation of the High Court is not held to be binding on the state, consequences will be unfortunate full stop. It is in public interest that the state will accept the recommendation of the High Court full stop. The vesting of complete control over the subordinate judiciary in the High Court leads to this, that the decision of the High Court in matters within its jurisdiction will bind the state full stop. The government will act on the recommendation of the High Court full stop. That is the broad basis of Article 235 full stop. In the present case, the order of the state retiring the respondent from service after the expiry of 3 months from the date of the order 19 August 1971 has been rightly quashed by the High Court full stop. The High Court did not make any recommendation to that effect full stop. Stanza. It is now time for us to take stock of the situation full stop in the light of the constitutional scheme guaranteeing independence of judiciary and separation of powers between the executive and the judiciary. The constitutional makers have taken care to see by enacting relevant provisions for the recruitment of eligible persons to discharge judicial functions from grassroots level of the judiciary up to the apex level of the district judiciary, that rules made by the governor in consultation with the High Court in case of recruitment at grassroots level and the recommendation of the High Court for appointments at the apex level of the district judiciary under Article 233 remain the sole repository of power to effect such recruitments and appointments. Full stop. The presiding officer of the court, if not being fully equipped with legal grounding, may not be able to deliver goods which the litigating public expects him to deliver. Full stop.